The Swashblade case and the importance of timing to coverage of risk. The recent Federal Court of Australia judgment in Swashblade Pty Ltd versus Liberty Mutual Insurance Company, 16 January 2020, concerned the entitlement to indemnity for damage under a cargo insurance policy. The case highlights the importance for underwriters, brokers, and insurers to check commencement date on insurance policies, ensuring that they take into account different dates and time zones between where the risk may be if different to where the insurance is taken out. In this case, it was a carrier policy and the relevant risk was at the loading port in the US. The insurance was taken out in Australia. The case also highlights the unique nature of marine insurance and the difficulty of determining what are the relevant terms of the contract of marine insurance, as maritime lawyers call it, as distinct to the from policy. The fact Swashblade Pty Ltd acquired in the United States of America and imported into Australia two Bell 427 helicopters. Liberty Mutual Insurance Company, the insurer, issued two aviation helicopter single transit policies of insurance in respect of both helicopters. The loading of two helicopters occurred on 18 and 19 May 2018 in Picayune, Mississippi, USA. The container used for the first helicopter arrived on 18 May. Picayune time, with the 15-hour time difference in Australia, this occurred at 6 a.m. 19 May. During the process of loading the loaders didn't apply chocks to secure the wheels. The loading of the first helicopter was completed by 5 p.m. on 18 May 2018, Picayune time, and departed from the port of New Orleans. At 8 a.m. on 19 May Picayune time, the same process took place in relation to the second helicopter. As with the first helicopter, chocking was not carried out. The container was loaded by about 10 a.m. and the truck departed shortly after. Following correspondence between Swashblade broker and the insurer on 22 May 2018, confirmation was received that cover was bound with effect from 19 May 2018, but it was not specifically stated whether this was by reference to Picayune time or AEST. The failure to apply choke caused both helicopters to be damaged during the voyage, and a claim was made under both policies. The insurer granted indemnity in respect of the second helicopter but denied indemnity for the first helicopter. The insurer denied coverage on the basis that the damage occurred on 18 May 2018 and therefore prior to the attachment of insurance on 19 May 2018 Picayune time. The case turned on the issue of what was the correct inception date from which cover was bound. Although the placement slip noted to the inception date as 19 May 2018, this date wasn't given in the context of mutually known circumstance as to the position of the helicopter. By 19 May 2018, the helicopter was already packed and stowed in a container and began its voyage by truck to the port of New Orleans. The cargo insurance policy. The placement slips were submitted under an insurance facility negotiated between us brokers and Liberty in May 2017 and extended in May 2018. A master slip records this facility, and from that placement slip will take. The class of insurance described in the master slip was helicopter cargo insurance single transit. Thus, the master slip investigates a specific single transit policy for each helicopter. The policy wording incorporated the 2009 Institute Cargo Clauses A. The period of insurance was described as risk attaching during the period from 23 May 2017 to 22 May 2018, both days inclusive LSD. The operative placement slip covering the first helicopter described the period of insurance as from 19 May 2018 to date of arrival at Sunshine Coast Airport QLD. The master slip contained a static cover extension, which states that coverage is extended to include static cover for up to 5 days prior to loading. The master slip also contained three conditions reflecting the helicopter's single transit endorsement contained in the correspondence policy wording. Coverage include loading and/or unloading, but not the risk of disassembly or reassembly, package or packing on the unit. Cargo professionally packed, stowed and carried and/or packing and stowage overseen by a qualified aviation engineer. Blade packed, stowed and carried in on box. These conditions were also contained in the operative placement slip covering the first helicopter. Clause 1 of the 2009 Institute Cargo Clauses A provided for the risk covered, which included all risk of loss of or damage to the subject matter insured, except as excluded by clauses 4, 5, 6, and 7. Of significance was clauses 4.3, which excluded loss, damage, or expense caused by insufficiency or unsuitability of packing or preparation of the subject matter insured to withstand the ordinary incident of the insured transit where such packing or preparation is carried out by the assured or their employees or prior to the attachment of the insurance. Clause 8. The transit clause dealt with the attachment of the policy and duration and relevantly provided this insurance attached from the time the subject matter insured is first moved in the warehouse or at the place of storage at the place named in the contract of insurance for the purpose of the immediate loading into or onto the carrying vehicle or other conveyance for the commencement of transit continue during the ordinary course of transit. The party's submission, swash plate. The applicant's primary submission was that the policy attached 5 days prior to 18 May 2018. This was because of the static cover extension provided for static cover 5 days prior to loading. Alternately, they argued that the policy should be understood as a voyage policy and not as a time policy, and therefore the policy covered the helicopter from when it was placed inside the container. The relevance of the date 19 May 2018 on the placement slip was only indicative of the expected start on the voyage.